Hello, everyone, and welcome to today's webinar. Thank you for attending. Uh, I'm Chuck Poplstein, and along with my colleague Jeremy Miller, we are happy to present this particular program about recent rulings changing the game for both union and non-union employers. This webinar is presented as part of Being Resourceful, Thompson Coburn's HR Law webinar series, which is presented by our firm's labor and employment practice. You can visit thompsoncoburn.com for information on next month's program and to sign up for future webinar invitations and alerts. A few housekeeping items I want to cover before we start. If you have any questions during the webcast, you can submit them through the Q&A widget at the bottom of your screen. We will try to answer these during the webcast at the end, but if a fuller answer is needed or we run out of time, we will answer it and follow up by email. A copy of today's slide deck is available in the resource widget, and we encourage you to download any resources or links that you may find useful. You can find additional answers to some common technical issues located in the help widget at the bottom of your screen. This webinar is CLE accredited in California, Illinois and Texas for 1 hour of general CLE credit, and in Missouri for 1.2 hours of general CLE credit. Additionally, it is CLE accredited in New York for 1 hour of experienced and transition credit, and it is also approved for 1 hour of SHRM and HRCI credit. We award credit based on attendance for the entire 60 minutes. You may notice that due to some of the changes in these various jurisdictions, we're no longer using the automated pop-up attendance checks. Instead, as required, we will be displaying secret words in multiple choice polls during the webinar. You will be required to select today's secret word from a multiple choice list. Please respond to these polls to demonstrate your continued engagement and to earn your full credit. We certainly do value your opinions and appreciate your participation in the course, so please don't hesitate to fill out the survey at the end of today's session. So in general, this presentation was prompted by a recent spate of National Labor Relations Board rulings and actions of someone who would be considered to be an aggressive general counsel of the board to enforce the National Labor Relations Act, and particularly to apply those provisions in non-union settings and just not the traditional things such as collective bargainings with unions or picketing or strikes or organizing activities. The increased awareness of the general counsel about application of the National Labor Relations Act to non-union employers also requires on our part increased awareness for you so you don't run into any inadvertent violations. And that is primarily the purpose and focus of our presentation today. For some of you who are experienced in the area and have dealt with unions on an ongoing basis and are familiar with the National Labor Relations Act, some of this may be old hat for you, but we think some of the overview here is important for all of you, and it's probably not a bad refresher. So I'll turn it over to Jeremy to talk about the Act.
Hi, everyone. Just a general overview of the National Labor Relations Act. It's a federal law that grants employers the duty to engage in protected concerted activity. So that could be strikes or picketing. It requires employers to bargain with a duly elected or recognized labor union. As it's enforced through the Interstate Commerce Clause, there are some jurisdictional limits. They're detailed on the slides. For most retailers, it'll be 500,000 or more. For non-retailers, it'll be 50,000 or more. And these calculations are based on different things. And there are also special categories of employers. So you might want to look into that. But it's important to know that we usually don't see employers contesting jurisdiction on these grounds because it's not a very steep threshold to meet. So the NLRB is a 5-member quasi-judicial body that administers the NLRA. Board members are appointed to 5-year terms by the president with Senate consent, with the term of 1 member expiring each year. And an independent GC is also appointed by the president to a 4-year term to investigate and prosecute any unfair labor practices. So you might ask, why is labor law constantly so back and forth? Because they're making administrative decisions, they're authorized to overturn any board precedent as they see fit. This means it usually flips based on political grounds. Once the board majority shifts, we see major pushes towards Democratic or Republican labor ideologies. Jennifer Abruzzo, the current GC, recently reaffirmed her August 2021 memorandum, which outlined an aggressive agenda to revisit and overturn precedent, particularly Trump-era board decisions.
So why should you care about this now? For exactly that reason, because the board, and particularly the general counsel, is taking an aggressive position to overturn prior rulings from the Trump administration in particular, and to make it very clear that the NLRA protections are going to cover both organized and non-organized employers. Also, because lately there's a lot more union-initiated strikes in 2022. They've also had a much larger average pay increase in labor contracts in over 30 years. But a lot of that, of course, is also due to the rampant inflation we've been experiencing recently. And there has been an increased number, both in unfair labor practice charges filed by unions or employees who are not represented, and also in union election petitions. And this includes in a lot of areas where we haven't seen that before. Particularly, you may all be familiar with the fact that Starbucks is being trying to organize shop by shop. A number of Amazon facilities have been organized or subject to organizing petitions, and we're seeing a lot more of that in areas which are not traditionally a subject of organizing. Jeremy?
Okay, so we're going to get into a brief overview of the NLRA. So under the NLRA, in Section 7, it protects the right of most private sector employees to engage or not engage in the following activities. That's the forming or joining of unions, group efforts to improve wages and working conditions. We usually hear that as group efforts regarding the terms and conditions of their employment. Any collective bargaining through a designated representative or group, and determining whether to have a union as their bargaining representative. Under Section 8A1, it makes it an unfair labor practice for any employer to interfere with, restrain, or coerce employees in the exercise of their rights guaranteed in Section 7 of the Act. And an employer violates 8A1 by imposing any rule that would unreasonably tend to chill employees in their exercise of their Section 7 rights. So who is protected under the NLRA? NLRA protections apply whether or not private employees are represented by a union. So we saw that in Washington Aluminum back in 1962. That was a case where several non-union employees walked out due to heating not working in the factory, and it was an extraordinarily cold day. And the court said that it didn't matter that they weren't union employees, they were still protected. And so it's just important to note that this applies to both union and non-union employees, because a lot of employers believe that since there's not a union representing them, their employees, that the NLRA wouldn't apply. One thing that the NLRA does exclude, though, is any individual having the status of independent contractor. And of course, that just goes to the traditional test of the amount of control the business has over the manner, method, and means by which the individual performs that work.
And by the way, when we specify private employees, uh, that is, of course, because the National Labor Relations Act won't cover people who are covered by the Railway Labor Act, who are involved in transportation, the rails, the airlines. Uh, it also will not cover state or local governmental employees. So, although there may be equivalent state law provisions for those types of public governmental bodies, they are not covered by the National Labor Relations Act.
So what kind of speech and conduct is protected under the NLRA? For activity to be protected, and that includes any negative comments, it has to be concerted. That means undertaken on behalf of a group, and discussions between or among employees have to be a logical outgrowth of group activity or collective goals. It's unlawful to discipline employees for making negative comments about working conditions, including comments about supervisors. That includes qualifying negative comments in social media postings. We're going to dive deeper into both of those aspects a little bit later during the presentation. So I just wanted to touch on it here. Conduct that may look to be an individual action by a single employee can also be concerted activity if the goal is to enlist the support of other employees and encourage them to engage in group action. So the classic example of this would be one employee is either handbilling or he's spreading information throughout the workplace about unions to try to gain support from fellow employees to unionize, and the employer takes some adverse action. So that could be discharge, but it could also be taking them off of certain assignments or giving them a little bit less workload than they were getting before. It can also be seen where a single employee is speaking on behalf of other employees in regards to any kind of working conditions that people have been having an issue with. So we saw in Every Woman's Place, an employee talked to several other employees about the holiday and compensatory policy, and they called the Department of Labor on their own to find out more information about holiday pay. And when they relayed what the Department of Labor said, they were terminated. This was found to be clear group activity.
And along those same lines, a couple other examples. One would be there was a situation with a private school, and it was a lot hotter outside than it is today. And the maintenance grounds crew was asked to go out and prepare the soccer field for the upcoming match for the high school students. And they said, all of them said, it's too hot out here. We're not going to work on that today. And so they left, and they were all dismissed. But unfortunately, what that really meant was they were strikers. Even though they were not actually represented by a union, they were engaged in protected concerted activity, and they can't be fired for going out on strike. They could be replaced, but they could not be fired going on strike. Or another example we had recently where one of the servers at a restaurant was complaining about the manager spending too much time up front with the receptionist and said, I think you're harassing the receptionist. And the manager said, why don't you go back to work and wait on tables because people aren't being waited on? And then he came back again and made the same complaint, and then he was fired, and the labor board took the position that that person was engaged in protected concerted activity on behalf of a third party. So Jeremy, what's not protected?
So individual statements and conduct can lose protection if they go too far. The NLRB has found that insulting, obscene, personal attacks against a supervisor are not protected concerted activity. We saw something like this in Mountain Shadows Gold Resort, which was a case in the year 2000, where the employee was essentially spreading disparaging documents about their company. They went to a different company to try to tell them that they, to try to ask if they wanted to run the resort instead of the management team that was running the resort. Some of these types of activity were just found to be a little bit too insulting because they were directing most of their comments at the ineptitude of certain individuals. But we will see in a case recently, more speech can now qualify as protected concerted activity. And I think Chuck is going to dive deeper into the changes.
Yes, we are. Just at the beginning of this month, the NLRB issued a recent decision that overturned precedent which had been established during the Trump administration as to when someone can be disciplined or dismissed when they have engaged in quote abusive conduct, or what some may say would be conduct which otherwise would be so egregious as to take it outside the protection of the act. The Trump administration board had established kind of a general precedent which said that ultimately, if a person engages in disruptive behavior, makes comments that might be considered sexually harassing, insubordinate behavior, or the like, that they can be dismissed even if it was in the context of engaging in protected concerted activity, as long as the employer can establish they would have been fired otherwise. So that seemed to be a fairly bright line test, and the current board decided we're going to go back to the prior standard, which is very much facts and circumstances, and in particular will determine that employees have additional protections when they engage in what otherwise might be considered abusive behavior in the context of protected concerted activity. And that will depend upon, so the context will vary depending upon the particular circumstances. So if you go into your boss and complain about the working conditions at the plant, and in the course of that, call the boss names, tell them he's stupid, tell them that he doesn't know what he's talking about, tell him you're not going to do certain behavior because you don't think that that's fair to the employees, that generally will be considered to be protected conduct, even if he said all those things without really urging things in favor of the employees as a group. Under this circumstance, they would be protected. Picket line conduct is even worse under the board standard. They have allowed people saying some pretty vile things on their picket line signs, or telling or speaking to people who are crossing the picket line that otherwise in the typical, on most laws, would be considered to be improper or unlawful. And that would be including, sexually harassing conduct, discussions about people's sexual conduct, profanity, and the like. If it's in the picket line conduct, in general, it's going to be entitled to even greater protection. Like what now, slightly different is social media posts and conversations between employees where a member of management is not present. So basically, if you want to look at it, kind of a summary, if you're going to mouth off to management when they're around and you're dealing with protecting or engaging in conduct that is on behalf of the group as a whole, or employees and their rights and interests, then you can get away with more than if you would just be on Facebook saying my manager's an idiot. So these are the general. So we just kind of covered this already here on this slide as well. But those are the standards which now are going to apply. The dissent, who was a leftover from the prior board, said, well, that doesn't make any sense because you're allowing people to engage in conduct that would probably violate the anti-discrimination laws and violate the sexual harassment policies of the employer. And as a matter of fact, the EEOC had submitted a brief as a friend of the court in this case, indicating that we want to make sure our laws are protected and enforced so there's not unlawful sexual harassment. And the board said we can deal with that on a case-by-case basis, and that really wasn't before them here. And they also noted there were plenty of times when they actually had fired people for engaging in disruptive behavior at a management meeting or insubordinate conduct. And that's all on a facts and circumstances basis. So to some degree, they, put out a little bit of a suggestion that, yeah, it's okay, we're not changing very much anything, but really they're going back to the old standard, and there's no clear way that a manager is going to know exactly what's permissible and what's not, except that as long as if somebody is really talking about workers' rights and pay and compensation and the like, then you are not in a position that you are likely going to, and you fire them for that type of insubordinate behavior, you're probably not going to be in a position of having that upheld at the board level. And by the way, the one thing I think we want to talk about as well along these lines is the whole concept of concerted activity, which non-union employers sometimes forget. And that is talking about compensation. And that means, can one employee tell the other employee what they're getting paid? Or if you give somebody a bonus and you tell them that they shouldn't tell anybody about the bonus and they do, and you fire them, then if they are covered by the act, and we will talk about who is covered by the act and who's not, then that would be an unfair labor practice and they would be entitled to reinstatement. As well as these days, the board is trying to seek even broader relief than just reinstatement and back pay. So one of the things to always keep in mind here for you all who aren't familiar with this, with the board rules, is you cannot prevent essentially hourly employees, non-supervisory employees, from sharing information about what they got paid.
And I think that's going to be a key point moving forward as we're seeing all of these pay transparency laws popping up around the country. A lot of employees are going to better understand that they are allowed to talk about compensation as a term of their employment. And I think we're going to see more of these kinds of cases arising.
And this whole concept of concerted activity and sharing information has really come to the fore with a significant board decision that was handed down earlier this year. But first of all, I want to pause as we talk about today's first secret word. The first secret word is non-union. So please indicate your choice on the secret word. Again, the first secret word is non-union. I'll give everybody a chance to make sure they get their participation in. In case you didn't hear that the first secret word is non-union, you'll remember to click that here. Okay. So, and that is the concept of concerted activity has been used by the labor board to get involved in the realm of separation agreements. And that means separation agreements for both non-union employers and union employers in cases involving people who are protected by the act. And again, Jeremy will cover a little bit who's not protected by the act. Just this February, the board dealt with a situation where the employer did a number of things wrong, and some of them which all of us would think were not wrong. They were a union employer. They laid off 12 union employees, without telling the union, without negotiating with them over the effects of the decision. And by the way, we can wonder whether or not you have to wait for the union to make a demand, but they just went ahead and laid off 12 people. They presented them with a standard separation agreement and a certain amount of benefits or payments for it. So they got a release and they got a payments. And they included in there the standard terms that you would probably see and most everyone sees in their separation agreements. One would be that the terms of the agreement have to be kept confidential, that the employee agrees not to disparage or criticize or make statements that could harm the employer, and that the employee will not disclose any confidential or proprietary information to others. And what the board did is they overturned a prior board precedent that was tied to saying that the only time it would be unlawful to include a confidentiality clause or a non-disparagement clause was in a situation where the employer had actually been accused of unlawful conduct by the employee in violation of the act, and there was proof of an unlawful intent. And what the board decided, and they went at great lengths to go over all this, is that merely offering a separation agreement, which included a confidentiality provision and or a non-disparagement provision, violated the employee's Section 7 rights to engage in protected concerted activity. You may say that doesn't make a lot of sense to me. Well, the board would say that is because you are buying off from the employee their right to assist other people in improving their workplace conditions, to assist other people in bargaining for better severance because you can't tell them how much you were paid, whereas ordinarily you would have a right to tell anybody how much you were paid, and the other employees don't have the benefit of knowing how much you received. And whoever wants to answer that can go ahead and do it. But they also would say that the non-disparagement provision limits the person's right to criticize management and to make comments critical about management and how they treat employees, and therefore it's broad enough to cover that, so you are restricting them from engaging in a right that they otherwise would have, which would be a right to make those kinds of comments as long as they are not maliciously false or reckless or disloyal. So that is where they handed down to that, which of course is problematic for all of us. In general, what that means is we only have certain options that can be discussed. Because essentially, and I jumped onto Jeremy's slide. Sorry about that, Jeremy. Essentially, we have three options here for those people who are protected by the Act. Either you don't include a confidentiality clause about the terms, and of course, in some states you can't do that anyway, depending upon the claims which are being asserted, or and in some cases, you probably don't care at all because in cases of layoffs and reductions in force, probably there's a uniform amount that you pay everybody. And in those, and you don't include the non-disparagement clause at all in those kinds of situations. Or you can consider including a provision in your agreement that essentially says, this does not prohibit an employee from engaging in any protected concerted activity allowed under the National Labor Relations Act or assisting in any investigation for violations of the Act or any other governmental investigation. Or you could try to limit the non-disparagement clause to conduct that is disloyal uh, and prohibit conduct that's disloyal or is reckless or maliciously untrue. Um, those are kind of your options for in for employers, for people protected by the act. And that includes, by the way, the board made it clear that that would even extend to former employees, because even though they may no longer be employed by you, they still have a right to go out in the future and use their experience at their employment with you to assist in organizing efforts or efforts to improve workplace conditions at other employers. Now, the one thing that isn't clear is whether or not including this type of language in separation agreements for protected employees makes the whole agreement unlawful, or just that makes that provision unenforceable. I think the general counsel has suggested that it may make the entire provision unenforceable. I'm not sure they're going to get to that point, but that would be a reminder for everyone that your agreement at a minimum should include a severability clause in the contract, which essentially says if any provision in this agreement is determined to be unlawful, it doesn't affect the validity of the other agreements and other terms in the document. And in addition, we agree to reform it to the extent it is lawful. So a lot to consider, and a lot which makes things problematic, particularly when you're dealing with the traditional hourly employee who is protected by the Act. Now, that doesn't mean you have to do everything the same. So the question then is, who is left? Under what circumstances are there individuals who are not protected by the Act? And I'll let Jeremy cover that.
So first of all, supervisors are not protected. And it's important to understand that some employees that you might not consider to be supervisors internally may be found to be a supervisor by the board due to the expansive definition that you should see on your screen. Any individual having authority in the interest of the employer to hire, transfer, suspend, lay off, recall, promote, discharge, assign, reward, or discipline other employees, or responsibly to direct them, or to adjust their grievances, or effectively to recommend such action, if in connection with the foregoing, the exercise of such authority is not of a merely routine or clerical nature, or requires the use of independent judgment. So that is a long definition that includes a lot of kind of key items that you should kind of understand how this works. So independent discretion is not by itself enough to label someone as an NLRA supervisor. The board said to look at that long definition and find three key things: the regular exercise of independent discretion, and then they have to display any one of the enumerated activities that they described at the beginning of that definition. And finally, they have to perform that in the interest of the employer. So it can't be that they are doing one of these enumerated activities in their own interest. They have to be either directed to do so or feel reasonably that they have the power to take one of these actions, and then to do it for the interest of the employer.
Now, and one of the things that there is a big fight about in most of these instances is the people in between who are someone who may have the authority to effectively recommend any of those actions. You know, you get in a situation where someone is a lead on the production floor and can effectively recommend discipline or dismissal of somebody. There's always going to be a kind of a gray line there on who's the supervisor and who's not. The board obviously is going to try to limit that as much as possible, and you've got to decide, particularly in situations where you are considering what to include in a separation agreement, for example, whether that person's sufficiently falling within the scope of a supervisor definition or not. The other thing, which is somewhat more difficult, is you're going to have a category of people who aren't supervisors, but who aren't necessarily what you would be considered to be the traditional production worker. There might be somebody who is in the marketing department and is maybe paid a salary, but doesn't really report to anybody and really isn't a member of management, but just kind of performs administrative functions. Or a bookkeeper along the same lines, not somebody who's chief financial officer or a bookkeeper. If you take the NLRA literally and the board enforces it literally, those individuals would probably be covered by the rules applicable to a separation agreement, which means that you can't include in the particular separation agreement a confidentiality agreement, and you can't include in there a non-disparagement agreement. And that obviously can cause some problems for you all, particularly when you're dealing with people when you don't even think about them being covered, right? Now, obviously, a bookkeeper who has access to confidential information may cover under Jeremy's definition here, but that's going to be a fine line. I think generally, the fact that they may have access to that does not mean that they are merely that if someone was the accounts payable is the payroll clerk and does everybody's payroll, doesn't mean that they're necessarily a confidential employee, but they also can't go about sharing confidential information to everybody about what everybody gets paid, but it's a very fine line there. So, Jeremy, you want to talk about confidential employees?
Yes, like supervisory employees, confidential employees are excluded from union
representation and not entitled to Section 7 protections. So these are employees who assist and act in a confidential capacity to persons who formulate, determine, and effectuate management policies with regard to labor relations or regularly substitute for employees having such duties. And so it's important to keep in mind that just being able to access these confidential labor materials is not sufficient. They have to work with them regularly. They would have to read them, be familiar with them. The idea is that you wouldn't want employees who are at the table understanding the reasons why the employer is making the decisions that they're making, and they have all of this confidential information in regards to why the employer is doing certain things. You wouldn't want them to then be able to turn around and use that confidential information against the employer. So some examples of these employees that qualify are secretaries, assistants to the supervisors or managers, or employees in labor relations or human resources departments that have access to all of the different investigations and all of the different confidential materials that the employer has.
And that would include people such as the executive secretary to the president. That would be another example. That person clearly would have a lot of access to confidential information, business plans, budgets, and the like. So now we are at today's second, and I will let you know it is the final secret word of the day. And the second secret word is employer. So please click in the appropriate place. Did I happen to mention that the second secret word of the day was employer? So before we go on to the next section of our presentation, I just want to circle back here for two things to remember. First of all, anytime someone is engaging in insubordinate conduct, inappropriate conduct, profanity, or the like to a member of management in connection with the assertion of rights for the group, compensation for the group, working conditions for the group, tread very carefully, because under the current rules for the board, that conduct is more than likely going to be considered entitled to protection under the Act, even if it was said in another context, it would be improper. So if Jeremy and I were working together, and just out of the blue one day we were having a conversation, and Jeremy told me that I was an idiot and I don't know what I'm talking about and I'm a tyrant, I might be able to dismiss him for that, for being insubordinate. That would be fine. But if Jeremy did the same thing, but first came in and said, I don't think that the firm and you in particular are treating our employees appropriately, and they're not getting paid what they deserve, and we need to continue to deal with those issues and they need to be addressed, and you're an idiot for not recognizing that, that is going to be protected. So in those circumstances, that's a fine line for you to figure out what to do. And the short answer, and by the way, that even includes when somebody would say to you, and by the way, if you don't like it and you don't agree with what I'm saying, then you can fire me. So even if they provoke you to fire them, that's still engaging in protected concerted activity. So no matter whether you're a law firm, no matter whether you're in the medical field, a doctor's office, or anywhere else it's not organized, you have to really, first of all, calm down and don't do anything without thinking about it, and go and then decide what to do. Or if nothing else, send them home with pay pending investigation. But don't act rashly.
And I think on
that point, I can just add,
I think that a real key is
that as soon as the employee starts talking about terms and conditions of employment or anything that could be seen as collective action, you need to be thinking about flagging it, because if they do then also, say some disparaging and insulting things
in the same conversation, or, lead into
insulting things about their supervisor, it can still all be protected because it was in the same conversation as the previous comments.
So then the second thing I want you to remember before we go on to the social media policy portion of the presentation is, again, you need to, for your employment situation, and consult your lawyer in particular here, but whenever you are using a separation agreement, you have to decide whether or not what you're going to include in the standard separation agreement that someone may have provided for you, whether that's a confidentiality clause or a non-disparagement clause. As we said, we've covered the kind of options which you can do. Obviously, the easiest option is not to include any of them in any agreement for someone who's not a supervisor or a confidential employee. Or you can try to include in all of your agreements an exception for this doesn't preclude you from engaging in any protected concerted activity or exercising your rights under the National Labor Relations Act or participating in any governmental investigation or proceeding. You could have that carve out. That may work, it may not work. The General Counsel has suggested that those kinds of blanket carve outs are going to be something that most employees won't understand what it is, and therefore you would be chilling the exercise of their rights because they don't know what is protected concerted activity. And so, but that's an option to consider. clearly, in those circumstances where you're just doing a across-the-board reduction in force, where everybody's getting, certain payment according to the same guidelines as everybody else, it's probably okay, and not even to worry about it. But the other way is to try to fine-tune your non-disparagement clauses and the like to fall within the board's parameters. But frankly, because the board's always changing its mind, then you're going to be changing your agreement all the time. But those are things you certainly want to consider. I know there was a question here about our lawyers and paralegals confidential employees. Lawyers would not be considered a confidential employee unless they are well, first of all, assuming they're not partners, partners would not be covered by the Act if they were true partners and involved in management. So if lawyers are involved in the management of the company, then they would be considered to be confidential employees. Paralegals wouldn't be considered confidential employees unless they were, in essence, subject to privileged information and they related to the activities of the company. And the same with the lawyers. If they're in-house counsel, then they would probably be protected and be considered confidential employees. Legal secretaries, the same thing. What information do they have access to? If they're in-house, the answer will be perhaps they are confidential employees because they would have access to internal information about their current employer. Legal secretaries who just generally are doing secretarial work for clients on behalf of the firm would not be considered confidential employees. For those people who are in management of the law firm and have the secretary work with them on matters relating to management, including budgets, finances, profitability, et cetera, they would be protected. So that's kind of a long answer to a short question, but that's generally how it would apply. For somebody like Jeremy here would not be as an associate at the firm, he would not be a confidential employee vis-a-vis the firm.
Great. Do we want to move into the next section then, Chuck?
That is correct. So
Great.
Social media policies are old hat for many of you. It's well settled that a social media policy likewise cannot be drafted in such a way as to prohibit people from engaging in protected concerted activity. And the board has has generally come down on approving a few policies, one of which was Walmart's policy a number of years back, which kind of outlined what you could or could not do. And those standards still apply. Now, clearly, for those of you who don't have a social media policy, you really should consider having one, because you need to figure out under what circumstances somebody should be saying things about on social media about the employer, about the employees within social media, employees on social media, calling them names or the like. Are you using derogatory terms about someone? Are you engaging in conduct on social media that would be considered unlawful harassment if it was at work? Those kinds of things are what you need to consider. So there's a number of, clearly talk to your lawyers, find out and review your social media policy. Here's a few recommendations that should be considered.
Yeah, these are just the recommendations that we usually begin with. Your circumstances may vary, so please reach out to a lawyer, reach out to one of us if you have any questions about these. But first of all, one of the big reasons why Walmart, their social media policy became a huge example as to how to draft such a policy is that it was the only one surveyed that the NLRB approved of because it used very specific examples, giving a lot of context so that
their employees really knew what kinds of posts they could make or could not make. So first recommendation is just to do that, just to give good examples, and that's the kind of thing that we can provide you with. Secondly, make sure that employees get approval to make any posts on behalf of your company, or any posts that could seem as though they're on behalf of your company. For posts about the industry, your company, or their work duties, just mandate that they disclaim that it's a personal opinion and that it's not the opinion of the company or on behalf of the company. And remind them that even if they do make that disclaimer, their post can still reflect on you. Next, we recommend that you prohibit them from making personal social media posts while at work. This can just help them maintain focus, but also they are less likely to make posts about the company or their work duties while they're off duty. A few more recommendations. Encourage them to fact check prior to posting and to remove or amend anything that they later find to be inaccurate. Prohibit them from knowingly spreading untruthful information. One thing that we see a lot of is just a blanket prohibition of all disparaging or defamatory comments about the company, its customers, or its employees. So be careful of these kind of blanket prohibitions, because some of this speech could potentially relate to the terms and conditions of their employment, and still be disparaging. So be careful not to prohibit everything, and to be a little bit more specific with that. And remind employees that anonymous posts can usually be tracked back to them, and their statements have the potential of resulting in liability for themselves and for the company. A lot of employees think that if they post on anonymous blogs or they post anonymously online, then it could never get back to them, but we see these cases fairly frequently. And the final recommendations are just to make sure you prohibit posting anything that could be threatening, harassing, bullying, and remind the employees to take care to protect both all of these, the companies, its customers, prospects, partners, and suppliers, confidential and proprietary information, and IP at all times.
And obviously and threatening includes no violent threats, no threats to harm anyone, etc. Again, because that's not in the context of asserting Section 7 rights, you have a bit more leeway there. But again, if somebody's is engaging in protected concerted activity and saying some of these things, whether it might be harassing or bullying, you never know where the board's going to come down on this one. And I think you've just got to tread carefully there. Now, this is a bit of a divergence here because it's not so much a question of protected concerted activity under the National Labor Relations Act, but it's something we're seeing a lot more of. And that is situations where an employee may, on their own time, on their Facebook site or their Twitter handle or one of the other social media sites, may be making political opinions, social opinions, which may be considered outside the norm, or may be considered offensive to some. And what may produce is a lot of efforts to cancel that person. And we've seen situations where employers have been inundated, and I mean truly inundated, with emails about why are you allowing somebody like that to work for you when they maybe make an inflammatory post about Black Lives Matter, or making inappropriate racist statements, or merely saying I'm supporting I'm supporting Trump, or I think the election was a fraud or whatever, and then you may get in situations where people are going to there's going to be a lot of pressure to take actions against an employee because of their personal views. I think the one thing we can remember here as private employers is that it still remains your providence and within your province as an employer to dismiss employees who are maybe expressing a political view or a matter of public interest in some regards, whatever's the latest issue of the day, as long as just for expressing their views, as long as they're not complaining about something that they think is a violation of their their rights. So for example, they can't be fired for complaining about discrimination or discrimination in the workplace in particular. But if they're saying something in the workplace or tied to the workplace, and it's they're complaining about something that they consider to be an unlawful employment practice or in violation of Title VII or the discrimination laws or the National Labor Relations Acts, they're protected. But there's a lot of things out there that are not protected, and that includes if they just say, I support X candidate. You don't have to, you do have some leeway there. Obviously, you always got to be careful about it, but you definitely do have some leeway. So that's just something to remember. We're seeing a lot more of that. I don't know how many of you have encountered or experienced that, but it's something to keep in mind.
Lastly, we just wanted to talk a little bit about some upcoming developments that we should look at moving forward. So in April, the board detailed a comprehensive explanation of extraordinary remedies for repeat violations. So a few of these included providing employees with an explanation of their labor rights, reading the notice/explanation of rights to employees or potentially by the supervisors or by management officials involved in those violations. They may also make supervisors or managers involved be present at the notice of rights reading. We've seen mailing notices to employees' homes, making managers sign them, publish them, post them for an extended period, or allowing visitations by board agents to inspect the bulletin boards and make sure that the correct postings are up. And in late 2022, the board said that damage calculations for unfair labor practices will also now include basically make whole provisions. So they'll include consequential damages as well as the damages that we saw previously, which were reinstatement, back pay. So anything that is a direct or foreseeable pecuniary harm. And the current GC has suggested that this should include pain and suffering, emotional distress, front pay, and legal fees. Now, the court did not go that far in Thriv, the board did not go that far in Thriv. They said that that wasn't a part of the discussion. So we foresee if that arises in a case coming forward over the next few months, so the board would address some of these other damage types. And finally, the NLRB released a proposed rule last September for determining joint employer status, and it deemed joint employers if they share or co-determine those matters governing employees' essential terms and conditions of employment. And we expect to see the final ruling on whether that's going to be the definition in September, or we expect it in August of this year.
And these are all really significant issues here. In the joint employer rule, that comes into play for a lot of people. For example, do you have a contract with a staffing company to provide employees on a temporary basis where they're employed by the staffing company? agreements. You see a lot of this, particularly in the tech field, where there are a lot of contractors and they bring in people to do coding or website development or the like. And there's been a push to make both the, to make Google as well as the contractor responsible for violations of the labor laws under the National Labor Relations Act, which likely will extend on to under Title VII and the Civil Rights Act as well, for employment discrimination. You will see that involved in the franchisor-franchisee issues. McDonald's is one that's been very out front and kind of opposing and saying this is, not appropriate and unnecessary. It would impact a lot of franchise or franchisees. The 2022 push by the board about damage calculations, historically, it's always been reinstatement of back pay. And the general counsel in particular is pushing with the concept then the problem is that every time people organize, then a lot of times they quote bad employers just fire everybody and worry about paying them reinstatement with back pay later on, back pay later on, that people get another job and they don't come back. And so they're trying to make it harder for people to use what they would consider to be a long time tactic in organizing campaigns to fire the ringleaders. The examples here that Jeremy gave about extraordinary remedies for repeat violations, you may have heard that one of these people that had to was ordered to do one of the readings of rights was Howard Schultz as chairman of Starbucks. And he had to go to a couple, he had to, I don't recall if it was, he had to personally, they ordered him to personally do that, or he had to do a video where it was personally played in the reading of the rights. So again, both the board in protecting the rights of employees as well as the GC in protecting the rights of employees has been clearly more aggressive in these areas. And you certainly, again, you need to be aware of those things and aware of where you may trip up, inadvertently have a problem without even knowing you had a problem. And so hopefully our presentation today helped you all to do that. The final question we had here was, can front pay awards be subject to limited duration, confidentiality, and proprietary rights agreements? If you mean proprietary rights agreements, that's, I think that is appropriate if you're just trying to protect your internal confidential information to trade secrets. Front pay awards, generally the board's going to say no for an employee who's protected by the act. And they would even seem to say it would go to, former employees as well have Section 7 rights even after they leave their employment. Any other questions? Hopefully this was informative and you all caught the secret words, and we certainly do appreciate your time today. And please be on the lookout for the next webinar from one of our other colleagues. And if you have any questions or think of anything, please don't hesitate to reach out to us directly. Thank you again.
Thank you all for participating.